At number 5,
Then I beg to appear on behalf of the petitioner, my lord. This is the exception. The matter I'm telling your lordship, the private respondent filed a writ applications for removing the illegal encroachment, my lord. Now, without disclosing the civil suit between us, the my lord directed to consider and dispose of by giving a reason of opportunity to all the affected persons.
With regard to private property, personal property.
Yes, I'm telling your lordship, without disclosing that, this order.
But who is appealing for the
I am private respondent.
Now, my lord, what happened, my lord? The 10-2 proceeding started, subsequently 10-3. Notice was served to my husband. Actual landowner is myself, petitioner herein. Now, my lord, challenging that order, petitioner and his husband moved an appeal under 10-4. Now, at the time of hearing, I will satisfy your lordships regarding 10-4 order. Thereafter, your lordship directed to file a report by the state. Now, my lord, will kindly take time to look at the state report. Report in form affidavit on behalf of respondent number 8, my lord.
Yes.
Well, got my lord. Well, do you kindly see page 2?
Yes.
Your lordship will find that I state that after necessary inquiry from the land records, acquisition, subject and such. Last line, accord in connection to Defense of India, case number under the Defense of India Act. Page 2, Roman 1. Under Defense of India Act.
Yes.
Well, the document annex also shows that it has been acquired under Defense of India Act. Well, do you see, well, page 4. My land is 111147, 34. From bottom, second column.
Yes.
Well, got it, my lord?
Yes.
Now, let kindly take table to look at my exception to the report.
Yes.
Exception to. Let us see. I have annexed the Defense of India Act.
Yes.
Exception in response to the affidavit 8. Now, at first, we'll kindly see the purpose of Defense of India Act, my lord. That is at page 7. I got it. Column 3. It shall remain in force during the period of operation of the proclamation of emergency issued on 26th October and the for period of 6 months thereafter.
But it will not affect there are other provisos of.
Yes, my lord. The previous operation or anything, well, it is in 1962. It is 1962. Its effect.
Even after expiry, these aspects will not be affected.
Yes. Now, my lord, you kindly see there is a provisions, section 29. That is at page 22.
Yes.
Column 3, whenever any property is requisition under 1, the period of such requisition shall not extend beyond the period for which such property is required.
You are reading
29,
29, yes.
page 22, section 29, subsection 3.
Yes.
Now, my lord, there is a provision for acquisition, that is page 24, section 36.
Yes.
Any movable property which has been requisitioned under section 29, my lord, earlier I show you, in the manner hereinafter provided be acquired in the circumstances by the government specified below, namely, where any works have, kindly my lord, take a note, during the period of requisition, been constructed on, in or over the property wholly. So, my lord, it is admitted positions, the land is in possessions of the petitioners. So, there is no construction on that period of time. Now, my lord, your lordship, this is the state's submission that under Defense of India Act, the acquisition was done. It cannot be done because it's, your lordship, I will show you the section 3. The purpose is for the periodic, for 6 months.
No, no, no. Please come to the remaining part.
Yes, my lord.
A, B, and C. Even after expiry of operation, these remain.
Even after when, my lord? When the property was acquisitioned under section 36. Kindly see, my lord. When a property requisitioned and acquisition, then
Where is that stated? Only in case of acquisition it remains.
my lord, kindly see, my lord.
Please come to 3.
Yes, my lord, I am coming to this. It shall
Operation of anything.
the PBS operation. No, there is no question of PBS operations. His statement, I will show you his orders. His order, I will show you, lordship, that
It was admittedly requisitioned during the subsistence of this act.
no, my lord, I am telling you, lordships. I came to know I have a 34 decimal lands. Out of that, but 22 decimals acquired, 12 decimals I have. Now, my lord, I record of right was published in 2 decimals. I filed an application for correction of record of right. Subsequently, this private discipline filed a petition. I came to know that my land has been acquired. This is the positions, my lord. I got that land by virtue of a gift from my mother. Now, your lordship will see that the previous operation or anything done duly done or suffered under the act. But nothing was done under this act. Here the report says the Defense of India acquisition. Only 2 documents submitted. Like, kindly see the report.
So that was under the act.
Kindly see that it should have to be acquisition first, thereafter acquisition.
This is a possession certificate, nothing else.
This is in 2 documents. One document probably that is not verified also. Second document, no signature.
There is only one document annexed to the report. That
2
is
documents.
a possession certificate.
Yes.
Nothing else.
So, my lord, how the acquisition nothing was. Now, my lord, lordship will see the petition. Petition. My lord, anything done means, my lord, here that the land acquired, subject to your lordship kind correction. Any
Acquired, anything done is.
it means acquisition to the land.
Confined to acquisition only. It may be requisition.
It may be requisition, but requisition, I told your lordship, requisition of for specific purpose. Clause 3, I show your lordship for specific period.
This is no. This goes beyond the specific period. That is what I want to say.
My lord, kindly see, my lord.
Yes,
So,
please make your submission. I'll pass out.
my lord, now, my lord, kindly take time to look at 10-4 orders.
At page.
At page 38, my lord, of writ petition. My lord.
Yes.
Well, kindly see the submission of the assistant, page 38, my lord, 3rd paragraph. The submission of the assistant engineer, Islampur High Division, such and such, and reports of the BLRO, such and such, clearly reflect about the fact of encroachment over public land. My humble submission, my lord, kindly see from the entire order. Your lordship will not see how the property was acquired, under which provision it was acquired, how much compensation was given, to whom compensation was given. Nothing. Kindly see order. My submission was not at all dealt with.
Where is your submission recorded?
My lord, my submission is instant appeal, page 34. First of all,
Yes.
Page 34 starts. Nothing dealt. Observation portion, I will show your lordship.
Is there any observation with regard to the Defense of India Act in the order? 10-4
Nothing.
Order?
Nothing. Kindly see order. Other exception.
Let the state respond to this.
Well, only one thing in addition to your lordship, my first point, I think, well, the state has himself admitted the acquisition was done under Defense of India Act. There is no doubt about that. So acquisition must be in terms of section 36, not any other section of Defense of India. So 36 says, my lord, whatever your lordship, I will show your lordship, what the 36 says. Considering the 36, my lord, if the 36 is done, then it has been validly after 6 months also. This is my, so far I have understood, subject to your lordship. If a 36 has complied with, then it will be operative after 6 months also. Now, my lord, another thing, my lord, during hearing, my learned friend shows that I have already admitted in my plaint that I have 32 decimals acquired. Respondent number 11, in his report, in his exception, filed it. Now, how he misled the court from day one, I am telling you, lordship. Kindly see my exception one.
Exception to which exception?
Second exception to the respondent number 11. Second exception. Just today I filed it. Exception. ওদের exception টা তো
Yes.
আচ্ছা my exception, kindly see, suit was filed in the year 2011. Kindly take table page 7.
Yes.
In the on 15th of January 2014. Got it? My exception, page 7. Information slip.
Yes, yes.
উপরোক্ত amendment পিটিশনে 15/1/2000 তারিখে allowed হয়েছে কিনা? Yes, my lord. Amendment was done 2014. Now, my lord, prior to that, the schedule was also mentioned. 12 BC mill. Kindly see bottom page, page 6. 22 শতক বাদে 12 শতক যার উত্তরে bottom portion, man.
So, in respect of the same property, civil suit is pending.
Yes, civil suit pending. Earlier occasion, what he said, my lord, kindly take his affidavit. 11 says that I myself admitted that I have the acquired land is 32 decimal, but entirely misleading the court that amendment was done subsequently. And from day one, my lord, they are misleading the court, although they have no status in this matter. Locus, which is petitioner between the state. Kindly see.
If the same property is involved in the civil suit, how can the writ court intervene?
My lord, the petitioner suppressing all these things obtained order subject to lordship kind correction. Now, my lord, 10-4 is I am challenging that I have no other options. I have to come before the writ court.
So you say that the petition, the private respondent
Yes.
suppress the.
Yes, I have
suit.
the petition. Nowhere averment regarding civil suit.
And it's the same property. How
Yes.
can it be dealt with? What is the plaint of the civil suit?
Print annex, C annex,
Declaration.
declaration, declared suit. Filed by me.
Filed by you.
Me, my lord.
Ajema Bibi.
Yes, my lord. And in a writ petition, I have not made party. My husband was made party.
What are your prayers in the suit?
Restraining him, my lord. Page 11. And permanent injunction. Declaration and permanent injunction. Injunction order আছে না?
So this is part of the civil suit, the same property. Yes, state.
Yes, my lord, whatever the petitioner has stated, my lord, what I understood, he is just assailing the acquisition order, acquisition process. My lord, kindly consider this. My lord, by this 226, generally petitioner prayed for quashing of the 10-4
That is
order.
clear.
Magar, whatever he submitted, my lord, I just understood, my lord, that he is, my lord, harping the, my lord, acquisition process, which has not challenged here. Kindly consider this. Secondly, my lord, kindly, my lord, come to my lord report.
Yes.
Before that, my lord, no, the 10-4 scope is very limited. In 10-4 order, my lord, the authority will not decide how the acquisition process come, whether they have received award or not. Encroachment has been done. It was found. Appeal against.
How was it found that, how do you say that it is PWD land? Please show me.
I am showing, my lord. My lord, kindly take my report, my lord. Paste.
Because your report says that it was acquired under the
Defense of India.
Act, but there is no document of acquisition.
I am
It is
showing,
only
my
a
lord.
possession certificate that you are showing.
I am showing, my lord. My lord, kindly come, my lord, page 2, my averments on affidavit. My averments on affidavit. That I state that who is, my lord, affirming the same, my lord, the executive engineer, Mushidab. I state that after necessary inquiry from the lands record of the land acquisition department, so it is, my lord, the record we bring from the land acquisition department. Land acquisition department, Murshidabad, it reveals that in respect to subject, the LR plot number such and such, RS number such and such, under Bouda such and such, the total 32 decimal of land of 30 out of 34 was acquired in connection to Defense of India Act 6/6566.
No document. Cannot be accepted.
Yes, yes, my lord, it is, we are not
When you
record
could
keeper, my
see
lord.
when you could see the documents from the land acquisition department,
We have,
what prevented you from filing the same before this court along with the report?
my lord, actually, this affidavit has been affirmed by the executive engineer.
Maybe whatever.
But my lord, the record should be, my lord, line with the, my lord, land acquisition, my lord.
Affidavit
I do
report
not know
was
whether
called
land
for.
acquisition.
Report was called for from the
Yes, my lord.
respondents.
But that has been, collected, my lord, and this document has been 30 years old, more than 30 years old, and this document has been, my lord, taken out from the proper custody. My lord, kindly consider section 90 of the Indian Evidence Act. 30 years document and taken from the proper custody. There should not be any
The
dispute, my lord.
document should be. You are aware of section 90. Please do not make this submission.
Now, my lord,
If the
what
document
happened,
is
my lord?
produced before the court, the 30 it is
My lord,
considered.
one thing, my lord, acquisition, land acquisition department has not been paid party, my lord. My lord, I am coming, my lord. My lord, I am coming. So, my lord, pursuant to my averments, I have collected the, my lord, documents which I have just annexed, my lord, at page number 4. That, my lord, in respect to.
What document have you annexed, sir?
Yes, my lord, that is the, my lord, kindly consider this aspect that the land, the record is too old, from 1965-66, and he is now assailing the acquisition after.
You are claiming encroachment on those two old records.
Yes, my lord.
So you must substantiate.
Yes,
that
my lord.
document.
Whatever I collected, my lord.
This is
Whatever
nothing,
I have collected, my lord.
this is nothing at all. That too or blank. Total area acquired blank.
But my lord,
What
in respect to
document is this?
1147, my lord, kindly see, my lord, left hand side plot 1147.
Who has given to whom? The position?
Position, my lord.
Given to whom? By whom? Where is that recorded? Can this be called a possession?
Yes, my lord. This document is not showing the same, my lord.
It is not showing anything at all, I'm afraid.
But my lord, it is showing, my lord, a authenticated document, a copy of the authenticated document, which is showing, my lord, in the 1965-66
Authentication during pendency of the
land has been acquired.
Where is it showing?
I am satisfied, my lord.
Anyway.
I am satisfying in other way, my lord. Kindly, my lord, take this, my lord, in the year, as per page 4, my lord, in the year 1965-66, the land of the petitioner 34 decibel has been acquired out of 32 acquired out of 34. Now, my lord, my lord had rightly pointed out, which just showed, my lord, petitioner, my lord, regarding the Defense of India Act, any operation has been done shall not affect the operation taken earlier, my lord. Just, my lord, pointed. Now, my lord, kindly, they, Pares, are supposed to produce the appeal copy, which was filed before the DF. My lord, kindly take, I have managed to, my lord, collect the, my lord, soft copy of the appeal, which is preferred before the DF. But I am
That
just.
is on record.
Yes, my lord.
That is on record, the 10-4 appeal.
Therefore, appeal petition
Copy-
is not on record.
Copy of the appeal petition is not.
Petition is
I
not
have
on
that.
record. Okay, appeal petition is.
Yes, yes.
My lord, kindly see the appeal petition. My lord, what I have just showed to my lord, the land has been acquired in the year 65.
You have not shown, I'm sorry,
My,
sir. You have not shown.
my lord, satisfying my lord.
A document which has been authenticated only in 2023.
Yes, my lord.
There is no other seal of the department, nothing.
No, I-
Cannot be, it's just a scrap of paper which has to be discarded.
My lord,
No value at all.
Well, actually, my lord, the prayer of the main prayer of the petitioner is not challenging the acquisition process. Kindly
He doesn't
consider
need
this,
to
my lord.
challenge.
He is
You
just
have
came.
said encroacher. So please
Yes.
show that he is encroacher. I do not find anything to show that he is encroacher.
My lord, I am satisfying. My lord, kindly come to my lord appeal petition.
Not only that, the tribal suit is pending before the
Yes.
before the civil court.
Yes, yes,
So
civil
how
suit
can
is
you say
pending.
he is encroacher before the civil court decides?
No, my lord, I'm stating, my lord, from the submission of the petitioner itself. Kindly, my lord, take page 2 of the appeal petition.
Yes,
Page 2, my lord.
yes,
Paragraph 2.
yes.
My lord, which I have showed just, my lord, land has been allegedly, my lord, suppose, allegedly acquired in the year 65-66. Now, my lord, kindly take, my lord, paragraph number 2, I am reading that your appellants, that means, my lord, petitioner and his, her husband, that your appellant state that the mother of the appellant number 2 gifted a dwelling house comprising in such and such land, Moja such and such, PS such and such, by way of registered Hebanama deed of gift recorded in book number such and such. My lord, kindly see the year. Kindly see the year. In the year 1991.
Yes.
So, my lord, it is admitted fact in the year 1991, the subject property which has been acquired far back in the year
Yes,
60.
because it has not been acquired. There is no document.
Yes. No, I am satisfied with the later stage, my lord. Because, my lord, it is not my lord, challenging the acquisition process.
Not
Kindly
necessary.
consider. He has just, my lord, challenged the 10-4 order. My lord, 10-4 order, what the DM will do? DM will, my lord, act on the basis of the record of the land acquisition department.
I want to see that record on which the DM has acted.
And one of from the report of the BLR, it is very well fully revealed.
Is that authentic? How does the BLLR said that this is government land, PWD land?
Well,
On what
actually, what
basis?
happened, my lord, the lab acquisition has been done, my lord, far back. It is, my lord, really
On
very
what
difficult.
basis do you say that it is PWD land and it has been encroached upon?
My lord, because, my lord, by the force of this document,
Because the documents show that it is the petitioner's land.
no, my lord, this document, how the petitioner came to know that he has the land over. My lord, kindly consider this paragraph number 2.
Yes.
He petitioner is stating in the before the DA that land has been gifted by his mother Indian in the year 1991. My lord, that means land has been, my lord, suppose for the sake of argument, allegedly acquired, my lord, in the year 1965-66. Then how the this transfer is, my lord, valid, my lord?
Provided you can show the acquisition, not otherwise. This is an absolutely valid transfer.
I will try to bring, my
Land
lord.
belongs to the mother. It has been gifted to the son. Absolutely fine.
Well, the
it's
acquisition
private
document is
property.
there, my lord. That's why I
Where
am
is the acquisition
just, my lord,
document?
placing this.
What do you call the acquisition document? Please show me. I see a possession certificate which doesn't bear any seal, signature, given by whom, to whom, nothing recorded. It cannot be called a document at all.
That must be with the land acquisition department, but by not
Must be, should be, the court will not
My lord,
consider. I will allow the writ petition. I'll quash
land
the
acquisition
entire proceedings
has to
until
be
Section
made party, my lord. It is also an important
10.
fact.
Entire Section 10 proceeding has to be quashed.
My lord, kindly consider, my lord. But
Yes,
section,
about consideration.
sir, it is my humble submission, my lord, a humble prayer, my lord.
Can you come back with the acquisition documents?
I will try to bring, my lord. My lord, I will try to bring.
If you cannot, it's all in
Try to
favor of the
bring, my lord. I
petitioner.
will try to bring.
Old record, my lord.
It is too old record, my lord.
No, but
I'm trying, my lord.
there is nothing on record to show that.
Possible, my lord, then I shall next.
Otherwise, it is evident that it is the petitioner's personal land.
My lord, kindly same time consider, my lord.
Consider what?
I will try
There
to.
should be something
My
before
lord,
the court to
later
consider.
state petitioner assailing the same.
Yes,
Such a later state petitioner assailing the
there is
acquisition
not
process
assailing anything.
without challenging the
Petitioner has been asked to leave the land, so he is before
I
the
will try
court.
to bring, my lord.
He is not assailing anything. It is for you to prove.
I will try to bring. I will
You are trying to throw him out from his own land. Yes, anything to add by the private respondent?
My lord, exception, my lord, file, my kindly see.
Exception to?
By the respondent number 11, my lord.
Exception or report?
Exception to the report.
Exception to which
Another
report?
thing, my lord. Exception, my lord, by the respondent number 11.
First exception filed by
File.
him.
File.
First exception filed by you. Where is that exception?
Respondent number 11, my lord.
Exception.
Another thing, my lord, completely new thing is here.
July.
এটা তো
My lord.
আপনারা ফাইল করেছেন।
আমি ফাইল করে সেটাই তো বলছি।
Exception.
হুম।
9 June.
কারা ফাইল করেছে?
What are filed?
হ্যাঁ, হ্যাঁ। 9
My lord, 9 June, my lord. Yes, my lord.
Yes.
Page
9 June
12.
2023 filed by him.
When
Page-
did you file the
page-
exception?
Exception, my lord, filed by him, my lord, private respondent.
By the respondent number 11, my lord.
To the report.
Exponent number 11 এর exception. Exception. এটা তো exception by the petitioner. Yes.
Page number 12, my lord. My lord, that report filed by the, my lord, petitioner in the, my lord.
BLRO file, report.
BLR file, my lord,
কি
in the,
বলছেন?
in the case of the, my lord, civil suit,
Yes, yes.
my lord, kindly see. The RS settlement, particularly in the decade of 50, the suit for plot bearing number so and so, area 34 decimal have been recorded in the name of Hanif and Deru Sheikh, son of Shukuddi Mondol, in 8 annas equal share in Khotian number so and so, Mauja so and so. My lord, government, West Bengal government acquired the shoot plot by RA case number so and so, department acquired by the 32 decimal, 2 decimal were left in remain. My lord, in third paragraph, kindly see, my lord. At this point of time, no difficulties, no complicities were present, but in the final publication stage, so and so the suit plot is recorded in favor of 4 different persons. That is Deru Sheikh, 5 decimal, Ekram Ali, son of Derestullah, 1 decimal, Mohsin Mondol, that is husband of the, that is husband of the petitioner, 5 decimal, and Mafikul Islam, Rashid, son of 1 decimal, and thus total area of 12 decimal, which are in anomaly, by whom this record have been produced by not find out of acquisition of land, acquisition PWD government of West Bengal in RA case number 7. Thus, this computer LR record is equal, is quietly unacceptable.
He is
That
supporting
12
me. Thank
decimal, my lord,
Does the PLLRO have any authority to give this report?
my lord,
To
my lord,
hold what
in the
is
civil
acceptable,
suit, my
what
lord,
is
in
not
the civil suit,
acceptable?
ask the BLR to file report. On that basis, my lord, report has been filed.
Does the BLLR have any authority to hold this? It's a ridiculous report.
My lord,
BLLRO is saying the LR record is unacceptable. What authority does he have?
my lord, that case is, my lord,
Says it is acquired by the PWD.
PWD, my lord.
The state says it is
Okay.
acquired under the Defense of India Act. Isn't it contrary? Contradictory?
My lord, that is case number is different. Different, my lord, completely different case. My lord, kindly see, my lord, on what I, my lord, kindly see.
28,
First
of
paragraph, my lord.
5960.
RA case number 28 to 5960.
What does the state say?
Completely different. It is not Defense of India Act.
State says 6566.
But yes, my lord,
Yes,
that is different.
Maybe it is a part, my lord. I do not
Completely
know, my lord,
different.
All maybe, can be, should be.
Different.
cannot
And
be
my lord,
accepted.
the
old
report,
record.
report shows that BLR himself admit there is anomalies.
Another thing,
Shown my learned friend.
another thing, what I found while just reading the petition at my lord, page 8, the petitioner is not completely denying the acquisition process. Kindly see.
Who says I'm sold
Kindly
22 decimal
cooperate.
acquired?
But my lord, he is disputing regarding the share. My lord, it is a factual aspect, my lord. It is my submission.
In any event, the writ petition and the proceeding goes. If you can still come back with documents,
I am trying, my lord. I am trying.
since I have expressed my mind,
I will try.
I can give you an opportunity to
I will
come
try.
back.
I'll try to give that.
The entire proceeding is dehors the law itself. You can take this back. Let the state try and come back.
And
Two acquisition proceedings have been referred to. One by the BLLRO, I do
Alright.
not know what authority he has, and the second by in your report. So please find out. The BLLRO says that the land has been acquired by the PWD, the land of the which the petitioner claims. So that also needs to come before the court.
I'm trying to bring the record, my lord.
there is an interim order up to 15 December.
It will be extended.
Then
You are claiming, yes.
The land acquisition collected is not the big part. Therefore, when all the papers lying with the land acquisition collected in the report, my lord.
Only for the papers.
Collected, my lord.
it will
It
The
benefit us.
additional district magistrate is a party. District
Land
magistrate is a
acquisition.
party. They are seniors, they are superiors. They can only for records.
Respond number 3 kindly. see.
Land acquisition.
Additional district magistrate land acquisition.
Concern authority with the records, my lord, to collect.
Only for records.
My lord, kindly
The
direct. my lord.
superior authority can call for records.
I will, I will
Necessary
communicate
to
my lord
add
to you,
more
my lord.
parties.
But my lord, if
As
kindly,
it is,
my
there
lord,
is nothing in this.
it will, it
Not necessary. The DM and the ADM can call for the records. They are parties. Give it a last try.
will benefit us, my lord, if my lord kindly.
The court is not here to benefit the state. Heard learned counsels for the parties. Paragraph learned counsel for the state respondents seeks accommodation to produce documents in support of the alleged acquisition of the plots in question as claimed by the state. Paragraph let the matter appear under the same heading on 19th January, sufficient time.
19th January.
19th January 2024, paragraph the interim order granted earlier is extended till 31st January 2024 or until further orders, comma, whichever is earlier. 19th January 2024. Oh, একদম শুরুতে exception used by the petitioner to the report in the form of affidavit filed on behalf of the 8th or 11th.
No, it's the exception in response to the affidavit filed by respondent number 11.
11th respondent is taken on record.